We're here today to conduct an interview of Jacob Hafter, who is the candidate for Attorney General for the state of Nevada. This is a gathering of the Independence Caucus. The first question: what is the concept of unalienable rights as mentioned by Jefferson in the Declaration of Independence?
These are rights that were given by our Creator. And it's interesting that regardless of all the separation of church and state rhetoric that goes on, our Declaration of Independence clearly says that we have inalienable rights given by the Creator. We have sovereignty as individuals, and we then have the right to turn around and loan that sovereignty to the state as a collective effort. And through that, they will engage in governance. But those rights are ours to begin with, and the government cannot take those away. Generally, our inalienable rights are something that I could stand in a box and exercise by myself. Freedom of speech, I could stand in a box, scream till my heart's content. Nobody can take that away. Okay, freedom of religion, I could stand in my box and pray or preach, either or, and nobody can take that away. All right. Privacy, even though that's not a direct right in the Constitution, it's one that's been inferred. And I can stand in the box, and God, I hope the box is closed and small, because that's the best way to exercise that one. But healthcare is not one that we can do that. You know, I can't stand in my box and take healthcare. I could refuse healthcare, but I can't receive healthcare. And so it doesn't fit the basic model for rights.
Explain your feelings about this statement. Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other.
I think that our founding fathers recognized that we need to have a positive culture in order to ensure a good government. And at the time, the way to ensure a positive culture is to have moral and religious principles,
right?
Founded basically in the Judeo-Christian roots. And so I believe that this statement is referring to the need that though having moral and religious principles is what's going to help us instill a good culture that will help ensure a strong government. I don't believe, however, that it is the government's role to say, you need to have these morals or these religious principles. I think that as long as you believe in a monotheistic society, that is based in fundamental Judeo-Christian tenets, those are a natural evolution. When you stop believing, when you don't believe in a God, you basically become apathetic.
As a public official, you will be required to take an oath to uphold and preserve the Constitution of the United States. When is the last time you undertook a serious study of the Constitution, and can you identify one or two areas where you feel the Constitution is being violated today? And if you have more than one or two,
well,
yes.
Can't wait for this.
We have limited tape, but there was this public discourse between Masto and Gibbons. And most of it was rhetoric. But on March 30th, 2010, Ms. Masto wrote Governor Gibbons a 3-4-page letter that provided her legal analysis as to why this case should not be brought in the courts, and the Attorney General's office should not bring this case. And I have direct knowledge that she released that letter directly to the press and to other third parties. Now, Rule of Professional Conduct, which governs attorneys, Rule 1.6 says that any matter involving the representation of a client is protected and privileged and cannot be released without the consent of the client. And what's interesting is she never got Governor Gibbons' consent to release that letter to the press, even though the letter was written to him. Now they try to say, oh, it was written on behalf of the state, and the state has a right to know it, but the letter was written to him. It wasn't written to the state of Nevada. And moreover, he also has not only the attorney-client privilege, he has the privilege as the governor, the executive privilege, to be able to deem any paperwork confidential. And regardless of this, she violated those obligations to keep it confidential and released it to the press. I issued a press release on April 7th responding to allegations that the governor's staff was making that they didn't waive that privilege. And basically I said, that I think it's a violation. I think it's grounds for her to be removed in November, and I'll be glad to remove her, and et cetera, et cetera. Then the following day, a reporter, quote, commented about this issue in an article. She didn't put any direct quotes to me. She paraphrased. So that was on the 8th, Thursday the 8th. Then on Monday the 12th, I was on John Ralston's show, and I broke the story about how the Secretary of State Marshall and Secretary of State Miller and Treasurer Marshall, both Democrats, are engaged in campaign ethics law violations. A call to action. I broke that story.
Troublemaker, weren't you?
I am. And the next day, at 10:30 in the morning, a reporter from the Las Vegas Review-Journal calls me up and says, not only is the State Bar not investigating Ms. Masto, we have confirmed that they have a formal grievance opened against you for the comments you made in the press release and for the comments attributed to you by the reporter.
She didn't attribute?
Now, so that was Tuesday. Wednesday, I responded. I responded on Tuesday. Wednesday, I actually got the letter from the State Bar. I don't know how the State Bar can talk to a reporter about an ethics a grievance file when they haven't even let the ink on the letter to the attorney dry. So I think, though, that it was all political.
Sure.
Of course it is.
And so on Friday, I filed a lawsuit in federal court alleging a civil rights violation under the First Amendment, because I think, call me crazy, I think that that's protected political speech, and protected political speech is one of the fundamental components of the fabric of our democracy. And I shouldn't even have to defend myself against a bar complaint related to political speech. It is absolutely protected. And that's, currently being litigated right now, and I expect an order to come out of the courts any minute, literally, on this issue. But I think that was a violation of the Constitution, and what did I do? I sued the State Bar to defend the Constitution. I mean, I know that I could have gotten out of the I know that it would have been dismissed, or I could have taken it to the Supreme Court. It would have been thrown out. But I said, no, no candidate who's an attorney should ever have to worry about having to defend themselves for political speech in front of the State Bar. The State Bar doesn't have the ability to regulate political speech or the election cycle.
Or anybody else.
And so we need to create a precedent here.
Right.
And so we went into federal court and sued. And that's kind of the way I am. If there needs to be a defense of the Constitution, you defend it. You don't just use it as a shield, you use it as a sword as well.